Hi everyone, Armine Bazikyan here from Bazikyan Law Group. I am a certified attorney here in California, specializing in wills, trusts, and probate administration. And today I wanted to discuss the 5 ways that you can transfer assets at death and what each of these ways will result in. So as we've kind of discussed in previous videos, one of the ways that you can transfer assets at death is by creating a trust and having the asset transferred to the rightful beneficiary through a process called trust administration. And that's when a person dies having left behind a trust which covers those assets. And this could be either, for example, financial accounts like bank accounts or stock accounts, or property. It doesn't matter what type of a asset it is, but they can mostly, for the most part, be transferred through a trust. The second way that you can actually transfer an asset at death is through a proceeding called probate, which is a court-supervised case or a proceeding that happens under the California court. A probate case, again, transfers the assets from the deceased person's estate to the heir or the beneficiary. And that's either done because the decedent had a will in place or didn't do any planning whatsoever, and therefore the court has to step in and supervise this transaction before the new owners or the new beneficiaries or heirs take over the asset. And again, this could apply to accounts, it could apply to real estate, it just depends on what the asset is. The third way that you can transfer an asset at death is through what's called a beneficiary designation. Now, I want to make a note here that not all accounts or not all assets have the ability for the person to designate a beneficiary or to use this process. A beneficiary designation form or a beneficiary designation clause is normally found when you have an asset that is, for example, a bank account, a savings account. So it's mostly accounts that allow you to have beneficiary designations, and it depends on the financial institution. Some financial institutions will allow it, some won't. So it's basically depends on the contract you have with the financial institution and what type of account that is. For example, life insurance usually has a beneficiary designation, which allows the decedent to put who they would like to be the beneficiary at their death. And so at their death, it doesn't go through probate, it doesn't go through a law office. Instead, that life insurance company will follow the instructions on that beneficiary designation. Now, the fourth way that you can transfer an asset at death is through what we call a survivorship clause. And again, this doesn't apply to all types of accounts. We see this very commonly with either a jointly owned account, a liquid account, for example, like a bank account that's owned in joint tenancy, where one person passes away and there's a survivorship clause written into the account where the second person automatically inherits without going to court or doing anything special. Or we see this with real estate when 2 people own property in joint tenancy and one person passes away. The survivorship clause automatically allows the person that's last standing or last man standing, when we have 2 or more people, to inherit the asset without going to probate. I want to make a note that the contract or the deed has to have the special language on there for a survivorship clause to actually take effect in order to avoid a probate process. And the final way that you can actually transfer an asset at death is through what we call a TOD or a transfer on death clause. Now again, it depends on the financial institution. Some accounts allow you to designate a TOD, some don't. It's not necessarily also for just accounts. You could do a transfer on death deed and have this applicable to real estate. It just depends on the type of real estate and what your wishes are. However, a transfer on death clause allows you to designate who you would like to be the beneficiary at your death, similar to a beneficiary designation, but it applies to some types of accounts at some financial institutions. So as you can tell, depending on the type of account that we're talking about, the type of asset that we're talking about, who the servicer or the holder of this asset is, whether it's, a big bank or a small little mom and pop mutual company, or if it's real estate, it depends on what type of asset we're talking about. The process could vary and the options can vary. So be very diligent if you are going to use any of these procedures. It's always, of course, best to consult with an attorney before you make a decision on which one to use. And there's also some negative and positive tax implications of using one versus the other. So for that reason, you always want to consult with an attorney before you make decisions, because you don't want to take an action that's going to negatively affect your beneficiaries or yourself from a tax standpoint. So feel free to contact our office. We provide free consultations. We'd be more than happy to let you know if your matter is something that we can take on. And again, my name is Armine Bazikyan from Bazikyan Law Group, and I'm a certified specialist attorney here in California, specializing in wills, trusts, probate, and trust administration. Have a good one.